Thanks, Sam, and welcome, everyone. Today, as we start to walk through some of the common errors that we see on signature card contracts, I just want to remind you, as we always like to remind you, that there are many variations due to state law issues. There's lots of different rules in each state, and some of those state law issues on deposit accounts and contracts may vary from something that I might say today. So I would always tell you if there's a conflict from the way that you learned it in your state, then you should always check with your local attorney and run it through them. One of the things that I like to start off talking about, just some general comments about signature cards and the contract that goes with them and the account agreement and how they're organized. I know there's a lot of different vendors. Some of you write your own contracts. Some of you buy purchase contracts from vendors. And in doing so, you really do want to make sure that you buy a contract that's in keeping with your state law, and that the accounts that are open, they're opened under the contract for the particular state where that customer is opening the account. So you'll see sometimes variations, especially if you're a multi-regional holding company, in the state laws from state to state to state. So you'll either use a different contract for each state, or a contract that you've managed to make a long enough one that it can accommodate all the different issues for all the states that you work in. But the signature cards that we're going to be talking about today, and whatever format yours are in, I just happen to format mine this way today for conversation, but they basically have 5 primary components. I mean, lots of signature cards have more than that, but from the legal point of view and the regulatory point of view, we have a box usually that we deal with ownership, and that's where we go in and say it's single party, multi-party, with rights of survivorship, without rights of survivorship, whatever the ownership type is, like Uniform Transfer to Minors Act. And then there's titling. Sometimes this is just a list of the owners on personal accounts. Sometimes we see cards that they go Bob or Carol. And then somewhere on the contract is usually a checkbox or a list of the federal regulations that we gave that particular type of account, and we disclose to them the federal regulations that apply to those accounts. For example, checking accounts would get Reg CC. All deposit accounts for personal, family, and household purposes would get Reg DD, and so forth. And then in box 5 would be the taxpayer identification number. And I know, I feel your pain in the last year or so. But many financial institutions have been getting letters from the IRS saying these names don't match these socials and these names don't match these EINs. And so it's really important to do our job as a withholding agent, and that is also accomplished on the signature card or through an attachment to the signature card called a W-9 or a W-8. And then where they sign themselves. And so signing the signature card becomes one of those important rules for opening accounts. There's so many times where they were going to take the signature card out and they never got their spouse to sign. Then we've got people withdrawing on the account who never signed the signature card. And I guess it helps sometimes to be kind of a black and white person, meaning seeing things in a concrete way. And I guess over the years of being in banking and training people that work for banks and credit unions, I've gotten more that way. But I just see, how can it be a contract if they haven't signed? How can it be one? But again, those are the kind of things that can get us in trouble as we go along. And I was teaching a group of tellers over the last couple of weeks. I've been doing some teller training, and I always tell them, if you haven't signed the signature card, you can't get any money. Can't hand out money if you haven't signed the signature card, because most account agreements have something in them that says, by signing below, you have the right of withdrawal. Well, if you don't sign below, then you don't have the right of withdrawal. And so that's always going to be one of the issues that we have on these signature cards. Now, some of you are getting very, very super advanced, and what you're doing is actually doing e-signatures, online cards, and all of that's fine, and all those types of signatures are fine as long as they're in keeping, again, with your e-sign law. So this is what we're looking for on signature cards, is consistency, and we're on slide 6. So the signature cards must be consistent. We want to match ownership with titling, with signatures. If I could tell you how many calls I've gotten in the 25 years I've done training over cards and what should I do with this? Well, once you mismatch the ownership, the titling, and the signatures, nobody knows what you should do. And that's when you'll be calling your local attorney saying, okay, we're probably going to go to court or they're going to sue us over this. And that's when you get into trouble. This is what I call the Bermuda Triangle when it's not done well. When it's done well and we say single party and Sally Smith signs and Sally Smith is on the title, then you got that perfect triangle. You've got Bob or Carol and it's joint, and Bob and Carol are on the title and Bob and Carol both sign. That beautiful triangle going on. Then we have a wonderful account agreement, and hopefully we'll have no problems with it over the future. But when we haven't set those cards right, when we haven't entered this triangle right, when we have it joint under ownership but it's titled UTMA and two people signed, then is it joint or is it UTMA, or will a judge decide somewhere down the road? And so these are the kind of things that lend to get us into trouble. And so we want to set up very consistent signature cards, and worked with a lot of financial institutions over the time, setting up signature card manuals where we actually have the sample signature cards for every type of ownership out there in that state or in that institution, and then hold people to an accountability standard. Because in the old days, and I can talk about those because I'm 55 this year, but back in the old days in our business, we had little 3x5 recipe kind of cards. We used orange ones for business accounts and green ones for personal accounts, and all people did was sign, and we set up accounts pretty much any way we wanted to back in the day. You know, that's the way we say it back in the day. But now, and particularly since 9/11, where we've gotten CIP into the game, I mean, we should not have this kind of mess that we see on signature cards around the country. We should have really great cards. And there shouldn't be as many excuses for some of the crazy things that you still see. Some signature cards add special features. So sometimes a special feature is a pay on death or a trust, in trust for, as trustee for. Sometimes that's a type of ownership on some cards. And sometimes on some cards there's a number of signatures required, and you can have 2 signatures required, but you can't say which 2 in a four account, owner account. You can't say which 2 can sign. And then some signature cards have agents or authorized signers, and in some states you'll see convenience signer as a type of ownership. So sometimes these are special features or accessories, and sometimes they are ownership types. Just be careful doing things you can't do, like number of signatures required. You wouldn't want to say 2 signatures are required, and then you know you can't do it. So you have to be able to, be careful about offering and misrepresenting the things that we can do and the things that we can't do. So with that kind of overview and thinking about these things, then let's go ahead and start working towards our common errors and some things and some thoughts as we go through. And what I'd like to do, and what my hope is today, is not to send anyone in a dead panic off and worried about closing their bank because they're doing some of these things, but more to stir up a conversation and a way of thinking about our signature cards and account agreements, and talking about how we could possibly do a better job. And if we're going to go in and replace signature cards in particular areas, maybe we haven't done a good job on sole proprietorships, or maybe we haven't done a good job on living trust, then you probably want to work them in descending dollar order, pull them off in descending dollar order. Somebody called me the other day and they said, oh, we're going to redo our minors. Well, pull them off in descending dollar order, because a lot of those minor accounts, they might only have, $5 or $20 in them. So we want to work them in our risk kind of parameter and in a way that makes sense if we're going to get into and start looking at these cards. Well, the first error that we want to look at is altering cards after the document is signed. So the customer could change their mind and they could alter their card. And so we find a lot of times the new account reps don't always want to, and that might be some of you, don't want to bother the customer and have them re-sign the document, so you'll just alter the card in your own handwriting. And when you alter a card for a customer and you're altering that card, then they've already signed it. So, again, some people say, well, we have them initially. Well, it's just creating more mess. It would probably be better just to redo the card in that case. So Altered cards after signatures creates problems for your